Hi friends, today we are discussing on mediation is referred, mentioned under different legislations in India. In those we are discussing mainly the Commercial Courts Act, Companies Act, Family Courts Act, Banking Ombudsman Scheme, many other legislations wherein it was discussed. And also, here we are discussing the proposed Amendment Bill 2021 and future plan of online mediation and ODR policy of Niti Aayog. And at the end, we are discussing on United Nations Convention on International Settlement Agreements resulting from Mediation 2018. In short, it is called Singapore Convention on Mediation. These are the legislations we are discussing, and we start with the Commercial Courts Act 2015. This act was amended and inserted new section 12A, pre-institution mediation and settlement. This particular amendment came into force from 3/5/2018. What this section, only one section, discuss on pre-institution mediation and settlement. What is the content of this one section, which is very, very important? What it says, a suit which does not contemplate any urgent interim relief under this act shall not be instituted unless the plaintiff exhaust the remedy of pre-institution mediation in accordance with such manner and procedure as may be prescribed by rules made by the central government. First clause is very, very important. What it says, where a suit which does not contemplate any urgent interim relief is not needed, then court should ask plaintiff to exhaust the remedy of pre-institutional mediation. If it fails, let them come back to the court. But what court says, first you go through the mediation. If it is settled, it's good. If it is not settled, come back. We'll continue in court as per the procedure. And for this, rules are framed by central government. We will discuss those rules later. Clause 2 talk about central government through notification authorize the authorities constituted under Legal Services Authorities Act 1987 for the purposes of pre-institution mediation. Everybody knows that this Legal Services Authority Act 1987 to help the needy people, to help the poor people, provide the legal aid, organize legal awareness programs. So that is the main object. Through this amendment, new work is given to the legal services authorities. At the, you know that at the district level, district legal services authority, state level, state legal service authority, and at the national level, national legal services authority. These authorities now have a duty to handle pre-institutional mediation under section 12A. So now these authorities are handling, organizing pre-institutional mediation. Clause 3 talk about Legal Service Authority Act 1987. The authority authorized by the central government under the subsection 2 shall complete the process of mediation within a period of 3 months from the date of application made by the plaintiff under subsection 1. So, third clause puts a duty on the legal service authority to complete this mediation process within 3 months from the date of application made by the plaintiff under this section, provided that the period of mediation may be extended for a further period of 2 months with the consent of the parties. First, it said within 3 months it has to be disposed of. Proviso says if both parties hopes that it will be settled, little bit more time is needed, then with the consent of the parties, mediator can ask for extension and another 2 months will be given, and within that 2 months, additional 2 months, the mediation has to be settled. Another proviso said that the period during which the parties remained occupied with the pre-institutional mediation, such a period shall not be computed for the purpose of limitation under Limitation Act 1963. This is also very important when the case is referred for mediation, and that mediation may take 3 months to 5 months, and those period 3 months to 5 months should not be counted when, in case the mediation is failed and case comes back to the court, when at the time of admission of the case they should not count these 3 to 5 months in the limit for the purpose of limitation as mentioned under Limitation Act 1963. It is one way encouraging the parties to go for mediation. Fourth clause talk about if the parties to the commercial dispute arrive at a settlement, the same shall be reduced into writing and shall be signed by the parties to the dispute and the mediator. Once both parties are happy on their terms and conditions, the agreement is prepared, that is called settlement is done, and that settlement agreement should be signed by both the parties and the mediator. So everything should be in written form. It should be only operative portion. There is no need for mediator to write all the things 3 to 5 months whatever they have done. There is no need for him to write in that particular agreement. Just an operative portion can be written, and for that both parties and mediator, all three, should sign it. And the last clause, the settlement arrived at under this section shall have the same status and effect as if it is an arbitral award on agreed terms under subsection 4 of section 30 of the Arbitration and Conciliation Act 1996. So this is another very important thing. Once voluntarily both parties agreed and signed for the settlement agreement, and also mediator signed. So whatever the settlement arrived voluntarily, and that is final, that is called as an arbitral award. It is considered as an arbitral award on agreed terms under subsection 4 of section 30 of Arbitration and Conciliation Act. So that is the value of the settlement. So this is section 12A, very important section. Through amendment it was added. We were discussing on rule 3 of Commercial Code, pre-institution mediation and settlement rules 2018. So there in rule 3 we discussed a party has to file an application under form number 1, and notice should be issued in form number as per form number 2, and if opposite party not replied, once again you can issue a notice under clause 3. So this is the format given at the end of these rules. Schedule 1, form number 1, heading form number 1 is a mediation application form, which is referred under rule 3 clause 1. Name of the authority and address, that is a legal services authority. If it is a Bangalore district legal services authority, if it is a state, Karnataka legal services authority. So then, and address should be mentioned at the top. Then details of parties, name of applicant, address and contact details of applicant, including mobile number, email, telephone, postal address. Then name of the opposite party, again all the information, so that notice can be issued even through email, and information can be given even through mobile. And details of the dispute, so short content, the nature of dispute as per section 21C of Commercial Courts Act 2015, quantum of claim, territorial jurisdiction of the competent court, brief synopsis of commercial dispute not to exceeding 5,000 words, because it's a short, the content sent to the opposite party, and additional points of relevance, if it any uh, facts are very important, that can be added. Then details of fee paid, so as we have discussed, 1,000 rupees DD has to be paid. So all the details should be mentioned, from which bank, which date, check number, DD number, so all those things. And form shall be submitted to the authority with fees of 1,000 rupees, and the box is for the office use. So legal service authority will fill up that particular box. So this is the format in which application can be made to the legal service authority by the applicant. And once application is made in form number 1, a legal service authority should issue notice to the opposite party to invite for the pre-institution mediation, which is referred under rule 3 clause 2 and rule 3 clause 3. So again here at the top, name of the authority and address should be mentioned, and content of this particular notice should mention where a commercial dispute has been submitted, fill in the blanks type of thing, party's name, who is the opposite party, and mentioning section 12A pre-institutional mediation, all those things, then opposite party uh, is here but directed to appear in person or through its authorized representative or counsel. So here, if the opposite party is busy, he can be represented by authorized representative or counsel on so and so date. The date and time is mentioned to the opposite party so that he can prepare himself, free himself to come to the uh, mediation, and for that purpose he has to, this document has to contain the date and time. And failure to appear before the authority by opposite party would be deemed as his refusal to participate in mediation process initiated by the applicant. Even after receiving the notice, if he is not coming, not replying, then the authority deemed that he is not interested. In case the date and time mentioned in para 2 sought to be rescheduled, the same can be done by the opposite party either on its own or through its authorized representative or counsel by making a request in writing at least 2 days prior to the scheduled date of appearance. So here the clause 4, the fourth paragraph, opposite party received the notice and he is interested to appear before the court, the authority, and on that day he may be busy. That's why he may ask different date uh, by requesting in writing at least 2 days prior to the scheduled date, and accordingly authority, here authority means legal services authority, depending on the territorial jurisdiction and pecuniary jurisdiction, so that has to be decided. The authority may be district legal service authority or state legal service authority or national legal service authority, and at the end authority address and signature of the authority and date has to be mentioned. Coming back to the same rule, rule 4, clause 4 talk about where the notice issued under sub rule 3 remains unacknowledged, or where the opposite party refuses to participate in the mediation process, the authority shall treat the mediation process to be non-starter and make a report as per form 3 specified in the schedule 1 and endorse the same to the applicant and the opposite party. So here notice is issued, but the opposite party refuses to participate in mediation process, then concerned authority shall treat the mediation process to be non-starter. It means the opposite party is not interested, and the authority should report the same as per form number 3 specified in schedule 1. We will look into the content of form number 3 later. Then clause 5